This is something that Carl's been
I found that. It's scary. I can't even get you my peripheral vision. When I can't see what Navy's doing, I'm kind of nervous. Followed by the sound of a racking shot. All right, we're in the
All right.
Okay.
So, one more second. All right, everyone should be getting a card with a state on it. Okay, that's good. So, basically, I want to cover a few things today. I want to talk a little bit about Law.gov, just give a sort of quick overview, talk a little bit how it sort of interacts with some of the stuff that other sort of free information legal projects that we're doing with myself and Tom and some of the other folks out there. And then I think we'll just open up to questions or whatever else comes up. I'd be happy to answer, anything that people are thinking about. So the first thing, Law.gov sort of started off with Carl Malamud, who I think many of you guys know from the SEC documents that are up, the EDGAR that's online for free right now. He also did a lot of stuff with patents, helping get those online over on the free website, on the USPTO website, and now of course Google's giving out a copy to everyone. If anybody has 10 terabytes of disk space, they want to play around with this stuff, you can download it from Google. So he started this project. He got a hold of myself, Tom, a bunch of others very early on, and we had a quick meeting over in Redwood City, and we talked about some different ideas, and then things started to take off from there. So I think one of the things Carl sort of looked to do, pretend I'm speaking on behalf of Carl, but he's looking to take lots of different organizations and different groups. So he has like the tech folks, like the Tim O'Reilly guys, and the real sort of real programming type folks. He's got the legal tech folks like Tom and myself, and he's brought in some of the law schools and law librarians, like Erica Wayne's here, and he's had a bunch of other law librarians working on different projects, but also bringing them involved in the overall movement as well. And then he's gone out and got the government folks as well. So both on the California and some of the different state levels, he's at many of these seminars that we've had over the last few months. He's had different state officials there, and then he's also brought in the federal government folks. So it's a lot of different people, but the overall goal of everyone is to try to get the sort of official laws of the land, starting with the codes and the regs, probably the things of most value, and then going to the judicial opinions, and then even things like some of the PACER docs and some of the other filings that take place online for free on a government archive that ideally can be pulled and sort of grabbed from anyone. In an ideal form would be an XML, but it doesn't necessarily have to be, so that you have this great archive of legal materials, and then you can sort of see what the community does with it or what the government does with it. But the main thing is that it's online for free, and people can actually start reading the laws and start seeing what's happening there.
When Carl came on the scene, there were really two things that none of us had ever yet been able to do very successfully. One was sort of, I guess I would call it break out of the scraper mentality that said that if we wanted to get information off of government websites, what we did was write clever scripts that ran around and sucked web pages and did various things with them, frankly never very successfully. We did it for a while with the circuit courts. It was a high maintenance activity. You've been doing it for a while. Alt law was doing it for a while. It's an ugly business. It's hard to do, takes time, so forth and so on. The other thing that none of us had ever really approached was the whole question of how you walk a public policy issue through the federal government. I mean, we'd all been off sort of hacking away without it ever really sort of occurring to us on some level that the first thing we needed to do was start calling congressional staffers and saying, hey, what are we going to do about this? And both Carl and the Sunlight guys were really sort of Washington types who thought that this was actually a good idea. And so that's been an immensely valuable effort. I mean, in some ways, we've really been too shy about the whole thing, I think. And Carl is anything but shy.
Yeah. Yeah. And I think that, sort of follow up, I think that's one of the core things. I mean, it's, we can scrape the stuff that's there, but at the end of the day, you really need the government to sort of take it and sort of run it. And the one thing that Carl's always done in the past is he's always done his work and sort of grabbed everything and taken it and given it back to the government. So, he was talking to the Ninth Circuit in the last week or so. One of the things he wants to offer them is the ability to have a complete copy of all their opinions and start helping them with their briefs and get that online as well. And he'll go through and he'll do all the work for them and then sort of hand it to them with the expectation that they would be able to take it going forward and keep it up to date.
I mean, a key motivator here right along has been the perception that, I mean, it's really counterintuitive, that government's access to its own work product is really terrible. I mean, it's really terrible. And so if you want to enlist government support for the idea of everyone having access, one place to start is by pointing out that they don't really have access to their own stuff. And I think that's what's been propelling this and a lot of the data.gov stuff as well.
So right now, let me just sort of give you a rundown where things are at. There's a large amount of data that you can download immediately on publicresource.org, and you can click in there and you can go to the Law.gov section of it. All the appellate opinions from 1950 to 2007 are up there for all the federal appeals courts, and that was something that was sort of bought or purchased from Fastcase. So Fastcase, which is upstairs at Walters, and some of their folks sold that over to publicresource.org, but at a very good, fair price. So it was actually a very big win. There's also I think like 43 states we have the codes up there right now, different years, and not necessarily all the latest ones, but those are up there as well. And then the Federal Registrar, the CFR, there's a bunch of other materials up there that you can also download. And the next steps, I think, well, I just say one more thing. The librarians have started sort of a listing of all the different resources that we're looking for in each of the 50 states, so which Erica was talking about at lunchtime today. And that organization is sort of going forward. And the next steps, I think he's sort of taking everything together, getting feedback, and starting to put together a report, which he's going to present out to Congress, the courts, and a bunch of other folks as well. I'm sure it'll be on the internet. So I'd say overall we're still at the very beginning stages of it, but he's certainly got all the people sort of communicating with each other and has gotten a lot of sort of support from the Obama administration and some of the tech folks there, in terms of really sort of pushing to get the stuff online for free and in bulk. So sort of doing on the data.gov and the apps.gov stuff so people can start playing and working with the data.
I mean, I think there are a number of crucial things that have happened as a result of this. I mean, one is that people are taking this question of bulk data seriously. One is that the technical and sort of intellectual communities around this have really come together behind it. It's been elevated to the level of a public policy question. There are people seriously asking, well, why don't we have access to this stuff? Which is, of course, quite refreshing for me, because we started asking that question in the early 90s and had never really gotten much of an answer to it. But it is, as Tim says, just the beginning. I mean, there are a lot of jurisdictions out there, and every single one of them is going to have to worry over these issues really until they get solved. The feds can be very powerful in leading the way on this, but at the end of the day, you've got 50 state governments and God knows who all else to worry about.
I guess the one other thing I would throw out there is I think a lot of folks, Bob Baring certainly one, but others have said that you really can't trust the government to actually be able to do this work. That you really need an outside group like West or Lexus that makes a lot of money that can sort of focus on the profit motive. And I think a lot of us have done stuff for free. LII, certainly the LIIs internationally have shown that this certainly can be done on a government or with government. But the main thing I would point out is there's a lot of stuff that's involved with making these laws and these rules. A lot of, or even like a court case. Parties have to get into a dispute, then they have to get angry, and then they have to sue each other, and then they have to file briefs at the district court level and go to trial, and then they need to appeal it, and they file more briefs, and the judge writes some random orders, and they write the final opinion. And apparently, some would say that the government's totally capable about being involved with all of that, but they can't do that last little bit, which is actually produce the final official version of that opinion. And that doesn't make any sense, I don't think, for any of us. Similarly for codes and statutes, they can pass the laws, they can get everything going, but they can't quite get it to the very end where they put up a a free version of their statutes, even though they're actually making codified statutes anyways. I mean, so those are the types of things where I think the marginal costs or additional costs to the government really is probably just imposing some rules on people to make sure they put it in the right format and sort of take it from there. Sort of like.
I think that's true. I mean, we've seen that done successfully elsewhere. The Canadians have done it for years. The Australians have done it for years on a sort of comprehensive national basis with open access for everybody. I would not argue that commercial publishers do nothing. I mean, they add considerable value. Everybody knows that. That's great for those who can afford it. It's probably essential at this stage for practicing attorney. But one thing that all of this ignores that we've discovered in however long we've been doing this is that there's a tremendous market for open access to this material that is not practicing attorneys and is not in fact doing the same kind of research that practicing attorneys are at least thought to do by law librarians. What they're doing is a kind of legal risk management or a much more casual assessment where they're going in and they're saying, well, what am I expected to do? How do I comply with this regulation? What do I have to worry about if I choose to take on this particular kind of business risk? And that is not at all the same sort of process as doing comprehensive legal research in high-stakes litigation. And so the idea, I mean, certainly you can service that market out of open access sources, and certainly you need more commercial actors than West or Lexis to be able to service it if you're not going to do it, for free. So the point here to some degree is to open up innovation for dealing with consumers of this information who have really, that's like a lot of other things on the internet. There was always a population that did this. They were served by various kinds of private publication, but until the internet came along, nobody quite realized how many of them there were. It's one of those aggregation things, and it's sort of high time that we dealt with those folks. And I think, one thing nobody's ever really looked at is how well smalls and solos are actually served by the commercial publishers, or to the extent. I guess that's not fair. I guess in a way that's what Ken Svengalis has done, right? But I don't know that I've ever seen anyone do this in a sort of comprehensive way. So saying, yeah, Rich.
If you're raising a point that's been a concern to me I'm a big supporter of Law.gov. MAL was one of the first organizations to sign a letter of support and all that. So I just want to make it clear that I'm a big fan of the whole movement and of Carl's. The thing that concerns me is that the quality of the product that I've seen so far coming out of the whole movement has been a little bit lacking. And if you go into public resource, you can get volumes of the Fed Reporter first series, but they're gigantic, entire volume zip files that crash my computer every time I try to open it up.
And that surfaces actually an important point that I'm not sure we've actually made, which is that the purpose of Law.gov per se is not to provide finished products for consumption by researchers. It's to provide bulk it's a wholesale business. It's to provide bulk products for use by people who are presumably have no social lives and sit in their basements and make decent products out of this stuff.
And to make the raw data out there so that you and your group can work their magic to make it
and 25 other groups doing 25 different kinds of things from 25 different perspectives, yes.
Because that, I think, is a really important message that I would wish to be made more strongly, because if the data is out there, but it's not, that's not necessarily the end in itself. We have to also, as a community, throw our weight, such as it is, or resources behind people that are producing usable data. Because if it can't be used, may not exist, may as well not exist.
No, actually, in a way that's problematic. I mean, I don't want to get up here and whine, but it's actually, as Carl has been finding out, it's actually quite difficult to find funding from government to do this sort of stuff, or even research in it, if you're not doing something that is kind of basic computer science research. I mean, we've bumped our heads against that for years. But by the same token, I would imagine that you and I could sit down with a sandwich and identify in the course of an hour 3 niche markets in Nebraska that nobody's servicing at the moment, that get interesting at the point where the data is cheap enough to allow 2 kids in a basement to do something with it.
Yeah, and I'm real interested in trying to develop those, because I really see the light now. But after having been to your program yesterday afternoon and seeing what goes into actually making that data, tagging it, and getting the format right to get it searchable, it's a lot of work.
Well, it'll be less work when we can reduce it to codebooks, and that's coming. But,
And maybe that's the solution, is for individual libraries in different communities to really focus their attention on their local resources.
well, I think that's right. I think that's right. But that gets us, you're veering now toward the whole sort of access versus ownership and what's exceptional thing, and we can do that all day, right? But other questions? Yeah, wait.
Just real briefly, what is the Free Law Coalition and how does it vary or different from Law.gov?
Right, well, it's a,
The Free Law Coalition was simply a marketing prank, because we really wanted to put a sign up on the table there that said, "Get your coffee mugs from the other guys. The only stuff we give away is law." Right?
but I think one of the, for us, with us and LII and some of the others, the Law.gov is getting the raw information up, getting up in bulk, and really at some point trying to get the government to take ownership of it. And I think once they start having archives up there, eventually the states will start sort of coalescing on a standard and things will get a little bit better. For us, it's getting the free information up, but also trying to involve the community and then also provide some usable archives of materials as well. So a lot of the things that we're working on right now is the WEX, sort of tying that in to allow increased participation on the WEX among attorneys, sort of get that up and going. We're going to be setting up an annotation system for case law, which will be done relatively soon for the Supreme Court, and will allow people to annotate Supreme Court cases to start with, and then probably next will be California, some of the other states that we have good databases on. And then we'll allow those annotations to be taken and shared with anyone. So you could actually have those annotations on your own site. You could download those as an XML file, or even get a live updates of it. And so that's sort of moving into the secondary materials. And then we have a lot of stuff where we're indexing blogs for both the ABA and our own site right now. We'll be integrating the blogs into this. And a lot of the core work on this, on the account side, Nick, who's in the back, and Dan just got done working on that. So that's going to allow us to sort of tie in these additional features for people logging in. And I know we're talking about the WEX stuff is latest this morning. So there's a lot of things that will be there involving the communities to participate, and then sharing that community information out with everyone.
Yeah, we're moving in similar directions, as we said yesterday, with crowdsourcing of commentary around the CFR and with integration with regulatory collections outside the United States. I mean, those are 2 things we're working on just at the moment. So, I mean, sooner or later, I mean, from our perspective, it's almost a research question as well, right? We're at the point now where people know basically how to put up large collections of primary legal materials. I mean, that's kind of settled technique on some level. I mean, there are always variations, but the basics are there. How we do interoperability, how we get this stuff talking to each other, how we set standards, how we integrate commentary, I mean, that's the next set of questions. If you want to be sort of flip about it, you can say, well, any damn fool can put up case law and a lot of fools will. But that's not quite true, but the point is that we need to sort of move on at this point and look at what the next set of steps is. The other thing I guess I would say about the Free Law Coalition idea, I mean, I was very glib about it, but I do think, for reasons that I think you are all smarter about than I am, I think we have a lot of selling to do. I really do. I think we have a lot of selling to do into the law library community in particular, which has been, to my way of thinking, unreasonably suspicious of resources. You might just say cautious. We seem to be battling that issue out in interesting ways over the whole authentication thing. In ways that, again, I think are the whole authentication issue. And I'm not sure I want to go down this rat hole, but I'll put one toe in it and see if I can pull my foot back out again. I do think that on that issue we've really been kind of talking past each other in some very interesting ways, right? Because from my point of view, it's about accuracy. It's purely about accuracy. I have no philosophical interest in believing that there is a glowing thing in the sky called authority that is somehow magically passed down into documents by the addition of an official stamp. And I actually have a lot of interest in seeing to it that that does not happen, because that tends to be a system that perpetuates official monopolies, which is something that I actually don't think we should have in this material, right? Nevertheless, I do understand that...
A defined monopoly wouldn't be bad.
No, especially if I'm God, but that's, but that's okay.
Take a vote.
No, but in all seriousness, I also understand the view that there are things that courts will accept, right? And that one must somehow sort of account for that. But anyway, that's just one example of a kind of bizarre little stumbling block that seems to be there, where we need to sort of explain ourselves as saying, well, look, we're not out to destroy the commercial guys. We're not out to wreck the idea of authoritative law somehow. But we do think that there are cost considerations here, that these things can be done more cheaply than they are, and that it's important to do that. And at least initially, I think we had a very hard time getting the law library community to understand that this was not somehow subversive, right? I don't know. I mean, only you guys can tell me why we shouldn't be doing what we're doing, or why one should be cautious about that.
If the I think I've come to the conclusion that over many, many years, the reason that there was sort of disagreement between the library community and tech community on this issue is we identified the wrong issue as the issue. We thought it was print versus digital. I don't think that it really is. I think that the issue is just, in fact, that's not even an issue. The issue is really integrity of the information. If you think about it, the law doesn't exist anywhere. It's just ideas. It just gets recorded in different kinds of formats. It could be, on stone tablets or microfiche or on computers or in paper. That it doesn't really matter which one it is. The important thing is what's useful, what's practical, and what you can authenticate. Paper is really easy to authenticate, and it's fairly permanent. Digital, we're having a hard time getting our brains around, and I think that when there was this whole debate between print versus digital, that was a red herring, and I think we wasted a lot of time. I think what we need to do is just put that aside and just start focusing on what's the best format for whatever's coming out of whatever source there is. What's the most useful?
Yeah, because I don't think there's anything about, well, actually Mike Washer, GPO, said to me one day, he says, there's nothing about authentication that is tied to any particular technology.
Yeah.
And I think that's actually right. I do find the state-by-state authentication report that came out of AALL frankly hard to read. And not just hard to read, but difficult to extract from it. If I read that document and I pretend that I am a state reporter of decisions who is trying to decide what to do, I see nothing in that report that would tell me that. What I see in that report is a bunch of stuff that basically says, print good. Right?
Yeah. Well, print is reliable. the thing that's nice about it, I don't have any paper around me, but, you can, whack it, and all the pages are still gonna be in the same order. It's really nice.
I can do that with
and simple.
Tim's
If I did that with my, I'm not sure.
I mean, the one thing I would say is that I think electronically, I mean, you really don't authenticate West or Lexus. In fact, their cases aren't exactly the same. They can always be different. And so it's really more of a branding issue and a trust of the brand. And I think that's another place where Law.gov, if you have a Law.gov site, where all these, the federal agencies and all the state agencies state governments are sending their stuff, all of a sudden you have a new brand of where you get the content from. And they'll start doing a better and better job to keep their overall brand up, because the government doesn't want to have bad data up there. And all of a sudden, you just have to authenticate versus that copy that they had there. And they sort of take some ownership of it. And at that point in time, I think you do all types of things and get over this authentication issue on the electronic side.
Yeah.
I worked on that report, and I think it was just trying to do a very simple thing. It was simply saying to the state, what should you do about it? It was simply saying the states were completely ignoring two important issues. One was whether the data was official, and the other was whether it was authenticated. Nobody paid any attention to it. And I think all it was saying is you should. And I don't think that's wrong to tell the states that. You ought to think about these issues instead of not thinking about them. I don't think it was meant to do anything else. It was sort of raising a red flag. I think that was an issue that people should think about.
Yeah, because there's an unfortunate reality about all of this that we can see from the fact that Arkansas just canceled its print reporting, right? And they're not the last. They're not the last. So there's an air of inevitability about this, right? I mean, sooner or later, one has to deal with the fact that there will be no print. Yeah.
Yeah, I just first a comment and then a question, and I think the comment is, I think where there's been a little bit, another source of maybe some tension or some pushback, has to do with, I think, the novelty of a bulk data approach to tackling these issues to certainly many in the library community, who are likely to respond, well, shouldn't we actually just asking the government to just put this stuff up and, imagining the system to serve it up and search and the user interface all really kind of a piece. So really this sort of layered, sort of tiered structure, I think is challenging to explicate if what we're looking toward is something where data flows to a repository from the agency, and then there are X number of downstream intermediaries building tools to access that and to serve that up and to provide an interface to it. And I'm trying to paraphrase concerns that I've heard coming from elsewhere, but I think that one response to that might be is that actually letting the official entities off too easy, and the pro side would be that hey, that's building a sort of competitive environment for entrepreneurs and nonprofits, but the other side of that might be, is it sort of further confusion in the sort of information space, apart from the sort of either the technical or the real legalistic authenticity question, is it just a sort of blurring of what is the source, what is the document?
It's an interesting question. It kind of depends on where you draw the line. I mean, for one thing, it would be what's your one question that you're asking. I would paraphrase or reframe as, okay, so how do you set the minimal level of value add that we consider to be a public good, right, of the sort that should be distributed by government and that everyone should have access to, above and beyond whatever the private sector or nonprofits or whoever else may decide to do with bulk data? Interesting question, and one place where it plays out in a way that I would think would be directly of concern to librarians is what you do about stuff like various kinds of metadata, document identifiers, citation, et cetera, et cetera. So, okay, just speaking as a geek, one level of value add that I might insist on as a basic public good is that we have unique identifiers on these documents such that we know what they are, that we can refer to them, and that we have some level of markup citation and and preferably vendor and media neutral citation, and so forth and so on, right? I mean, there's a scat of stuff you can run through like that, some kind of basic interoperability standard. Interestingly, we don't have that now. I mean, it should be pointed out that, as John Jorgensen has said to me many times, a print citation is not a unique document identifier by any means, and if you look at regulatory stuff and so forth, it's even worse. Beyond that, you know, where do you want to set the dial? Where do you want to set the dial? What is the public entitled to? The maximum amount of value add that the government can afford? What I think it was you actually who was pointing out in the noon session that when you talk about codification, you know, if you look at the feds, okay, that's a public good, but if you go out to the state level, it's a privatized activity. So where do you want to do that? I mean, there's this whole sort of policy debate that has to be had about that. Tim, I'm sorry.
I don't think anything would keep the government from doing add-ons or doing additional work on it just because they put up in bulk. So I think that's just one part of it. They might have their own site and do their own stuff over here for the public as well. So I think they're sort of two slightly separate issues. Although I think the citation stuff is something that you'd like to resolve and get everybody to agree on at some point.
And I guess the sort of question piece of that goes then to the, you know, sort of what's good enough. And then if there's at least sort of two different points that you might have, you know, a sort of more entrepreneurial kind of an approach, right? And one is almost at the end stage, right? Carving up a niche product, serving it up directly to the customer, very targeted. And then the other is closer to the data, right? And that seems both sort of higher risk and less glamorous in some ways. And that's, so, you know, what's good enough for, you know, a feed or a bulk that needs to come from the agency that's going to enable, that's going to be at the point where it's actually possible for someone to you know, to do, you know, data cleanup, and, you know, what's robust enough and clean enough.
Yeah, it's
And I think that goes actually kind of to what I take to be what this whole thing is, the kind of question this whole thing is about asking.
I think you're right, and I you know, I'm intellectually interested in this enough to want to start looking at some other areas as well. So, for example, one place where government has clearly done something about this, but I could not tell you what, is with GIS data. You know, where there's obviously been some kind of policy consideration about what's a free good and what isn't, and what's a vendor value add and what isn't, and so forth and so on. I have no idea how any of that was worked out. But it's a very parallel situation. You have an enormous amount of data whose distribution is in the public interest that was essentially generated at public expense. And you have to make decisions about where you're going to draw the line between what, you know, USGS is going to do and what Garmin's going to do.
Yeah. You said that you didn't anticipate or see this as a substitute for Lexis and Westlaw, or something that eventually would bring those down. And I'm wondering, why not? Why don't we want to bring them down? I mean, they cost too much, and our students aren't able to find jobs, and we need to cut costs. And why don't we find something that, why can't we get this taxpayer pay for information for free rather than paying an arm and a leg for it?
Now, I don't think you need to bring them down. You might want to give them more competition, whether it's Fast Case. I mean, Fast Case has a lot of deals with bar associations as well. A lot of people have free access to, you know, all 50 state law there. Rather than, and I think rather than focus on bringing them down from that standpoint, you know, they charge what they want. You'd like to have alternatives for folks. But like some of the stuff that you see right now on the net, like one blogger was getting cases from Lexis. He was given them, and he was given 1 year to use them. But apparently he thought he could use them for a year and sort of keep them up. And they said, no, you got to take it down. So he took down his whole blog, took down all the secondary materials. So I think part of it isn't necessarily taking down Lexis or West, but providing an alternative with both the raw materials as well as some of the secondary materials, allowing the community, especially on the internet side, to be able to tie into these raw materials in terms of links and things, so they can, you know, do their own value add. While Lexis and West, I mean, that's systematic sort of annotations of cases, doing the separatization. That's a whole separate world, which I think is always going to exist. especially the large-scale litigation that takes place.
I got quite an education a couple of years ago. The Hague Conference on Private International Law was thinking about coming up with some sort of convention that would encourage member states to do open access publishing of one sort or another. And they had a bunch of people on it. It's fascinating to watch those guys work because they are sort of plumbers of the international law scene. Right? I mean, there are 68 or 70 signatories to whatever it is that empowers them to do what they do, and they basically publish these international conventions that people sign on to. And one of the things they've been very concerned about is the way in which somebody in Jurisdiction X can get definitive answers to questions about the law of Jurisdiction Y. And one has the feeling that this has perhaps been more of a concern of late because a lot of this stuff is matrimonial law in the EU, where someone's coming out of the Middle East, where answers are hard to get, and et cetera, et cetera, et cetera. But you watch them talk, or you listen to them talk, and their work is sharply bifurcated. On the one hand, they hear about stuff where there's some zillion-dollar construction project in London that's financed out of the U.S. with a German guarantor and a Danish construction company, and something falls down and everybody starts suing each other, and there's lots of money on the table. On the other hand, you have the French guy who marries a German girl, moves to Denmark, has 2 kids, and gets divorced. There are 2 very different price points in those markets, right? where what they're willing to pay to get a legal question answered is concerned, and they need to find a way to service both of those. And my suspicion is that there will always be a very high end to the market where the price sensitivity on the cost of getting a question answered is they'll pay whatever they have to be sure that the answer is definitive. Everybody else needs something cheaper. Erica, I saw your hand going up back there.
2 things. I guess one, and I think this is worth saying if you're newer to the Law.gov, vendors have actually been really interested in the process, or more interested than you might expect, because I think they know that it provides easier access to the stuff that they're spending a lot of money putting out there. And data that they're not putting up there right now, there's no municipal code stuff on Lexis. That could be on there. So stuff that they haven't even tapped into. I mean, they're probably salivating in something else. But then they also could probably invest more time into making it richer, better, the stuff that people want to pay for, too. So I think it's funny, you think about them kind of being against it, but I think they actually might be interested, or at least, I know Lexis has been more interested in it than Lexis claimed. But on a related thing, I think it's something Tom was saying, this is going to the Free Law Coalition selling the Free Law Coalition. We're at such an interesting point, like economically and for digital generation. I don't feel like the lawsuits I see today have the same issues of trust that my generation or older folks, I will say, maybe had. And I think this is ripe. I mean, I don't think they have the same suspicion. I was even talking to Cicely, a friend. Like some of the students don't even care when their name is up on a site and they don't put up good work product. I don't think they have the same issues with public identity and public space. So I think this is a good time to really do more with it. They're just so bright that way.
I have a question about pacing. I should know this, but does the government contract that out to someone else too, and is that why it costs so much?
They might have contractors. I don't think
Yeah, the systems integration on it, and the actual machines that are spitting out bytes, I think, are actually contracted out. And I'm thinking that perhaps it's Lockheed Martin or one of the other 13 large federal systems integrators who tend to do that stuff. It's the usual suspects are people like Lockheed or Booz Allen or others. So my suspicion is that that's involved. Yes.
But I think they've gotten fat off there. I mean, that's what it is. Greed is really part of the price mitigation. They're making so much money, making more than they need.
I think they saw it as a windfall initially, right?
There's a lot of efficiencies. I mean, they could all use the same system. Every court does their own. I think Steve Schultz has written about this a lot online. So there's a lot of things that just to make it better and more usable from that standpoint. And they are making a lot of money off it, so it seems. And spending on other court materials where I think the law says they're only supposed to spend whatever money they make on pacer and keep the cost down to the minimum. So maybe that's not 0, but it might not be 8 cents a page.
The last session said 2 cents a page. Is that what that costs?
Yeah, Leo.
Yeah, you mentioned integrating that LII, I think, was working on integrating regulatory collections outside of the U.S., and I just kind of got interested. What do you mean?
We're starting, we have a couple of research partners, one in Italy, one in Spain at the University of Barcelona. The three of us are very interested in developing retrieval system, semantic web-based stuff that would essentially allow you to look at a US reg about XYZ and find the similar Italian reg or the similar Spanish reg. Because it is ontology driven and because automated ontology construction is not exactly what you would call a settled matter at this point, a lot of human expertise is needed for ontology development, and so we're choosing to concentrate on an area that will get us the maximum political and grant leverage, which at the moment we think is food safety. It's an interesting problem because it goes back and forth between the EU and the US. It's also a problem because it rattles around at the state versus federal level here. And even within the Fed. I mean, there was a New York Times editorial in the wake of the pet food scandal a couple of years ago that identified 17 separate federal agencies as touching food safety in some way or other. And there's no retrieval system, even within the federal government, even regulations.gov, that would allow you to search comprehensively for that stuff, or even make a layperson aware that there were that many people touching the issue. So, you know, we think it's a fruitful area to work in. It's a little bit science fiction-y at the moment, but in 5 years it certainly will not be. I think in 2 years it probably will not be. There's been an enormous amount of work done on this by the research community in the EU for reasons that you are probably much better acquainted with than I am, but regulatory harmonization has been a huge concern there since economic integration came along. They put a lot of money into it. There are 3 LII people sitting over there saying, what the hell is he promising? And John.
This is something that you kind of touched on before, but I don't know if you might want to say some more about it. But just thinking about some of the questions that have come up already and what everybody's had to say about it. The question that comes to my mind is that, you know, a rich, powerful organization can do a great deal to put out real quality product. But a lot of people, and you've talked about price points, not, you know, everybody doesn't need that. And the thought I have in my head is really, how good is good enough to be truly useful to the average person who needs information? So my personal suspicion is that that's not a really high bar. It is a bar, but it's not awfully high. I don't know if you want to some comments more about that.
Well, I'd get my academic on at that point and say it's an understudied problem. It's an understudied problem because we don't really know enough beyond the anecdotal about what people outside the legal profession actually do with this stuff. We have guesses, but we've certainly never looked at it even at the level of very sophisticated log file analysis to say just, you know, what the hell are these people doing? Why are they here? What are they doing with this stuff exactly? I mean, we don't really know. We have our suspicions. We get email, you know. And the other thing that is kind of not clarifying things is that nobody has ever, well, that's not true. There has not been a lot of serious looking at what price-sensitive legal research would be for non-lawyers. There are a lot of assumptions in legal research teaching about it having to be done in a way that is, and this is how you would teach it, right? Having it done in a way that is suitable for a high-stakes sort of situation, right? But very little has been said about how you compromise. You know, the question, what is good enough, I don't think is a common question in law librarianship, is it?
Not in law librarianship. As far as practical lawyering is concerned, there's a lot of discussion about it, and lawyers talk about it all the time. People talk about it all the time, and people seem to be very satisfied with a great deal of stuff that's out there.
Yeah, I mean, you
To the
could,
extent that they can be satisfied at all, perhaps.
well, and you can also raise the question, and no doubt someone will in the next 5 minutes, about whether they're going to hurt themselves or not. And, you know, Cook raised that question in the 17th century, but I don't know that it's a serious concern. I mean, to some extent, I mean, on the other side, on the sort of public side of this, the question we've been trying to answer for a long time is, what does legal WebMD look like? You know, and we're not really sure we know.
You know, what I would say is that for most people, they don't even want to read the laws or the cases or anything. They want like a summary of it, like a no press type of thing. And in terms of like searches or visits, I could sort of break that down. Employment's the biggest. And it's mainly people at work looking up the employment laws when they should be working, probably. So it's that one. It's family law, divorce, and landlord-tenant. And those, if you look at those big three, I mean, you're looking at probably 60% of the traffic. It's not maybe a little bit of criminal once in a while, a little bit of injury, bankruptcy, everyone, but those are the big three, and they're repetitive, and they're basic questions. You know, my shower's not working, I had to hire someone to fix it, can I deduct that from my rent? Types of things.
And for most of those, the statutes will give them the answer.
Hard to read it.
If the statutes can be interpreted by the people reading
Yeah.
them. But I mean, in most cases, it's not going to be changed by some court's opinion.
Well, yeah, I mean, one of my favorite things to do in a room full of law teachers is to start asking questions like, okay, so tell me which parts of the Americans with Disabilities Act the average carpenter can't read. And of course, you know, there's always somebody who has to jump up and say, well, you know, reasonable accommodation, just so that I'll know that they're paying attention. And, you know, you sort of want to look at those people and say, you know, law schools spend a lot of time dealing with constitutional edge cases. The rest of the world does not. And if that's really the way the legal system works, if you can't read the ADA without having some idea of what you're supposed to do, without delving into 87 Supreme Court cases having to do with reasonable accommodation, well, then why hasn't economic life in this country ground to a complete halt? Because clearly no one can do anything, right?
For people, it's codified statutes and regulations.
Yeah.
And that's pretty much it.
Awfully quiet all of a sudden.
By people, do you mean the pro se person?
Yeah, public, not lawyers.
The lawyer loves this stuff.
Yeah.
What's good enough for the lawyer is very different from what's good enough for the pro se person.
I'm very suspicious of the use of the word pro se. And I always jump on people for this, and I'm sort of mean about it. And the reason is that the people who are using my website are not representing themselves in court. They are not pro se. They are people who are trying to get their bearings. You know? I once sat in front of a seminar at Cornell. Someone had asked me to come in and said, you know, I'm kind of a legal publisher, and one of the things I worry about is this whole question of ignorance of the law being no excuse, right? Because that's why you publish law. I said, but I want to approach this in a slightly different way. When I say that, who do you imagine is ignorant, and what do you think they're ignorant about, right? So we start going around the room. And it's very clear that these are all very sophisticated Cornell law students who are not going to be so melodramatic as to say, oh, it's some guy in court defending himself on a murder charge, right? But they were clearly kind of thinking in-court felony, you know, what have you. 14 of them in a row. 15th guy looked around the room, looked at me and said, hell no, it's some guy with a regulatory problem. He was a German LLM, right? But I mean, I think that really most of the time the people are, if you look at our website statistics, most of the people who are coming there are looking at the US code. And they're not doing anything per se with that. And I don't mean to pick on you, it's just that every time we do this, we hear pro se, and it's not that. It's just not that.
But they're not going to court though.
No.
No, so they need some information, it doesn't have to be what the Philadelphia law firm or New York law firm cares about.
No, exactly.
But as law professors or law librarians, we don't know, we have to give them everything.
Mm-hmm.
So we're just always being excessive.
Mm-hmm. Mm-hmm. Yeah, I think so. I think so.
I mean, I got a side question. Do people teach fast case right now in the law schools? Because that's real at Stanford and other schools.
We show it, I don't know if you call it teaching it.
They got a lot of neat tools there, but they have everything. It's very low price point, or it's free.
Well, it's
like
free, though.
16, 18
So many
bucks.
states, including
Yeah.
Ohio and Kentucky both.
And they've been sort of doing, I mean, they have a nice complete set of stuff, and they've been adding a lot of features into it. And they've obviously been very supportive of Law.gov as well, from that standpoint. But I think we've seen some law firms now adding fast case, at least out in Silicon Valley, they add fast case as an additional purchase item to West or Lexus, and that's what they use for their case pools and some of their additional research that they use. And that saved a lot of money for these firms.
I guess I'd like to actually ask you guys something, which is kind of the used car salesman question, right? What do I have to do to sell you this car? If we are to provide stuff, if we are to provide open access to stuff that the law library community will use, what does it have to be?
You know, it's an interesting question that you raised. You know, the most important stuff for practitioners on a day-to-day basis, I don't think is the primary law at all. It's with secondary materials is what they need. Handbooks. I practiced I was a firm librarian in a firm library for, I don't know, 7, 8 years. And that was, we had the codes, we had the recorders, but even, well, anyway, it was the secondary materials. It was to get to the cases that they wanted, and just in that phrase, that carries a secondary, a search tool notion with it. That was the most important thing. And so, it's rare that they came and just said, I need, this section.
Right.
They wanted to know what the section meant. And experts are the ones that do that.
Yeah.
And piggybacking on that, as an academic, one of the things that I would personally really like to see, well, as far as, I think secondary sources are important for students too, just for practice instruction, not even necessarily case analysis or anything like that, but, pretrial skills, stuff like that. So one thing that I would particularly like to see is court documents, like motions files, so that they can have sample motions or sample documents to go as, sort of a pseudo causes of action kind of thing to go with a particular fact pattern, point of law, what have you.
So I think
I don't know if that's something that you guys will be
So
able to
harvest pacer and have somebody figure out which the best examples are.
So that's going to be indexable relatively soon. You'll be able to search across at least what is like a third of all the documents that were filed for years for free. And the guys over at the recap project is doing that, and they have all those documents as well.
One thing, our law review just put up its entire content in digital commons by bpress. When we were working on getting that content up, I was really surprised at how different schools handle that data. It's actually difficult to search at articles because they're behind so many, not walls, but so many clicks in that Google, I don't think, crawls that deeply into.
But I think bpress right now
What's that?
is bpress will be working on their optimization
Are they?
for those people that want their articles crawled by Google. That should be increasing greatly. So
Well, even if people don't want it, if they're putting it up on their digital commons, shouldn't it be available to?
You can keep Google from indexing it, and some might want that, some might not. I mean, if you want more traffic to it, obviously you'd want to open it up and put the right title tag in and do like 5 things, and it'll be fine. And bpress has done a much better job of that than like SSRN, but they still have a ways to go in terms of optimizing those articles for placement.
But that would be another thing to get searchable in 2 ways, to be able to search into the journals and law reviews that are online, but then to be able to parse those to create a collection of cases that are cited in law review articles. If you could take, of all the law reviews articles written, the cases that were cited among those, you've got the cream of the crop, the cases that are the most controversial, most instructive. That would be a cool database.
I am pretty convinced that the most elderly arthritic, hidebound conservative member of the federal judiciary is about 6 points more of a free thinker on this issue than the average editor-in-chief of the Law Review in the law school. You know, I'm absolutely convinced of this. I don't know what it is with students that they think that they have to out-curmudgeon what they see as the prevailing culture, but in this respect, I think they absolutely do. And it's
only about 3 years,
Yeah.
any decisions.
It's bizarre. Susanna, you were going to ask something, I could tell.
Oh, it was about the briefs. We've been dealing with this horrible brief database thing. And we have questions about copyrighted briefs. Does anybody, I mean, you can't seem to get a firm answer on copyright briefs, so.
You're not going to get it from me, I'll tell you that.
There was an article written about whether lawyers can copy other lawyers' briefs, but.
I don't think it's ever been enforced from that standpoint.
Probably not copyright, it's probably theft.
Yeah.
Well, it is the sincerest form of flattery.
I mean, I think Milburn Boyce tried to copyright their briefs for securities filings, I mean, before they were going to prison for stuff, but, yeah, I think they just dropped that part. But others, and there's a California lawyer who's trying to do it just mainly because Wes and Lexus are selling it. He'd like it to be up online for free. I'd say the other documents you might want to check out, there's a site called 1CLE, one of the guys in our office runs. It's not a CLE site though, who runs Google AdSense on. But it basically, he goes through SEC documents, there's all these great contracts and has broken them down by, you know, here's the license agreements, intellectual property licensing, or here's different employment agreements. And they're actual real contracts that are filed with SEC filings. So they're very high level contracts and of huge value. You can actually clip and copy different parts out of there. And he has thousands and thousands of contracts up there, which I think, at least for the transactional lawyers, is very, very high value.
What did you say that was?
1CLE, ONECLE.
I think we got time for one last shot. Should I declare adjournment?
Well, I'm going to say one last thing. I think getting the primary materials up is actually helpful for the secondary materials, and having people link to them, and that's one of the large items for it. So it'll actually, if you put good primary materials up, I think you'll actually create more secondary materials and more people working on it. And it might be, you know, somewhat like you see right now with bloggers working one at a time, but also you might start seeing groups of people like they do on Wikipedia, but maybe law professors on Lex and folks putting things together.
I think it's true. I mean, we've become keenly aware of what we talk about internally as the kind of Russian doll problem of wiki construction with experts, and that's why we've been taking our student labor dollars and channeling them toward dictionary definitions. Because, you know, someone comes in to write some secondary thing, they realize, oh, wait a minute, I need a defined term here. Oh, wait a minute, I need a defined term inside that defined term, et cetera, therefore write Russian dolls. So a very nice area to have students working in, a very nice area to sort of try to crowdsource if you can, is the creation of a basic dictionary. And unfortunately, there is no dictionary more recent than the 1860s that is out of copyright. And Fred Shapiro refuses to do it for free. So.
No one's going to help.
Last chance. Go forth and have snacks. Piece of promise to right there.
There's an article, Law Library Journal article, that Weber tried a while back to track the and this person was
state law library. And what she was saying in her speech was, we're wasting so much money buying all of the reporters from commercial sources. What a waste. It's all public. All with the state law librarian or the
And that's because, Rich, since ILL, it's the only successful known example of cooperation with librarians on a pragmatic level. Let's use it for everything. You gotta hammer everything's a nail.
well, right. But this was also or something like that.
It's not the other thing with
The way they were looking at trying to solve
It's in 1994.
you know, in some ways, it's an analog
Shag
version.
carpeting. Shag carpeting.
The library doesn't have all the codes, but at least they're not copyright. Copyright so they're missing, so it's like, you go all over it. You guys see some ones that aren't copyright. The guy who was the lawyer. I finally found out something about that, so I might get one of the law library. I think the law goes to take on. You gotta get the law administration on top of it to make it. Okay. You can't just a lot of resources are something to talk about. Everything doesn't see up there in the government. I want to take it all federal reports. That we got from not using it, but that way. See, like the Facebook's just sort of just dragging over with it all, where each schools have their own, so they can keep it with it. You know, you go through, they have all their own cases, so everything is interlinked to the musical environment, which means
we're basically on the practice and whether or not you're actually working with it.
In other jurisdictions, they don't. They're very selective. They only publish. And with this sort of provider that they're revealing, it would be interesting to know what that would look like.
they have some real value. They don't waste your time.
So,
And I do think
there's always been a movement to sort of read through all the cases, all the duplicative, all the useless cases, and then just begin further. A way. And I've thought about that a way to approach that. Go through all of the law reviews, law journals, and then just all of the
I think until Robert's made this thing published or anything, but I think there's a big one on that got hit was that when any protest was West, the West, to compete with West, he was like a public opinions he could. So he went into like this craziness, just like saying they had more opinions on it. And then West had to respond. And all of a sudden, you take the major people and you put them on the crowd out there. And he did the same thing as everybody will set annotations on each one. But I think the Lexus West marketing value is what actually led to non-legal publishers just taking over everything.
If you actually prejudice from my law. So they don't pay up in some kind of, and they realize that they have is just all, you know, the system.
That's a large set of secondary. Oh, yes. I know these law professors, they're doing their case, you know, a few guys make money off case books, most of them make nothing.
Yeah.
They get together, start making case books and horn books as a group. All of a sudden, everything's moved.
Oh, yeah. That'll happen.
And I got this one guy, he has this class action defense, technical class action defense, Michael has incredibly well-written stuff. I mean, a lot better than the random editors they had in Eden. And you look through it, you know, he does it for marketing credit, but the stuff is written like for general counsel audience, it's hard for me to read. And if you start taking community as well,